which was just signed now by the applicant in this matter. Your Worship, I can confirm that I'm appearing in this matter with my counsel, Advocate Mohamani, as previously appearing in the matter. Your Worship, counsel will proceed with arguments in relation to this particular matter. At this particular stage, Your Worship, I am in possession of the particular affidavit which has been commissioned and the annexures which are attached to the affidavit. With the leave of the court, may I beg leave to read same into the record? Scott, please, Your Worship. I will make a copy available to the state as well. The affidavit reads as follows. In the Regional Court for the Regional Division of Gauteng held at Johannesburg, case number 41/0318/2020-16 in the matter between Oupa Brown Mogotsi, applicant, and the state, the respondent, affidavit in support of bail application on new facts, either undersigned Oupa Brown Mogotsi, do hereby make oath and state as follows. I'm the accused in this matter, and I make this affidavit in support of my renewed bail application for bail. I reside at number 4544 Mohata Close, Mabatu, Unit 13, which is my permanent place of residence. The facts contained herein are true and correct, and unless otherwise indicated, are within my personal knowledge. This is a bail application on new facts and changed circumstances not fully placed before the Honorable Court at the time of my initial bail ruling. I was previously denied bail by this Honorable Court on the 4th of June 2026 on the basis of concerns relating to my address. At the time of the initial bail application, the contents of the docket were not available to me or my legal representatives. The landlord from my previous address, Mrs. Memory Catherine Jacoba, Herhold, had not been supplied to me or my legal representative relating to the visit by the investigating officer. My long-term neighbor, Mr. Maxwell Senukwani, had not been furnished to me, which statement addresses the visit by the investigating officer had not been received or known by me. The Wi-Fi statement in the name of my wife, Dorothy Oarabile Lukwaba, had not been provided by my wife at the time of the initial bail hearing. The precise Google Maps coordinates of my residence had not been furnished. The aforesaid new facts are to be enclosed here too as follows. These are the annexures. It is the affidavit of memory, Catherine Jacoba Herald, it's OBM 1. Affidavit of Maxwell Senukwani, proof of residence and ID as OBM N2. Affidavit of Dorothy Lukwaba and NETX Tech Wi-Fi statement dated from 1 September 2025 as OBM N3. The picture of GPS Google Maps with my address as OBM N4. I request that the contents of the said affidavits be read in and incorporated herein as evidence in my bail application on new facts. New facts and changed circumstances. Since the initial bail application, the state has made the docket available to my legal representatives. Upon perusal, it has become clear that the docket is voluminous and contains complex expert evidence which will require thorough consultation and preparation for my defense. The inability to consult properly with my legal representatives while in custody severely prejudices my right to a fair trial as enshrined in terms of Section 35 of the South African Constitution. Furthermore, I require release in order to raise funds necessary to properly challenge the expert evidence presented by the state. This is not possible while I remain in custody. My continued detention limits my ability to properly consult and prepare for trial. I have further been furnished, as detailed above, evidence that I obtained recently pertaining to my address verification, details which the investigating officer did not inform the court about at the time of the initial bail application. It was important in the interest of justice that this information be placed before the court, as the initial impression that the investigating officer created was that my address did not exist or positive, which is not correct. My wife also deposed to an affidavit detailing the address issue and annexed a recent statement of the Wi-Fi, which statement dates back as far back as last year, which indicates that my wife and I have been residing in the said address for some time. The strength of the state case and absence of video footage, I further wish to bring to the Honorable Court's attention that despite the state's reliance on alleged video footage as a key piece of the evidence, no such footage has been furnished to me or my legal representatives to date. The absence of this video evidence, which the state claims forms the basis of its case, raises questions regarding the strength of the state's case against me. I submit that the lack of access to this critical evidence does not justify a finding that I'm likely to evade trial. On the contrary, I have every intention to stand trial and clear my name. I respectfully submit that the current state of the evidence does not support any inference that I would abscond if released on bail. Addressing previous reasons for bail denial, the Honorable Court previously denied bail due to the concerns regarding my address. I'm also willing to comply with any conditions, with any additional bail conditions the court may deem appropriate, including but not limited to regular reporting to the Mogotsi police station, surrendering my travel documents, adhering to a curfew, or any other conditions the court may impose. Procedural fairness and Section 60, subsection 3 of the Criminal Procedure Act, I respectfully draw the Honorable Court's attention to provisions of Section 60, subsection 3 of the Criminal Procedure Act, which requires that bail proceedings be inquisitorial in nature. Section 60, subsection 3 provides that if the presiding officer is not satisfied with the evidence before him or her, he or she must request the presentation of such further evidence as may be necessary to inform the decision. At my previous bail hearing, the Honorable Court indicated that the landlord was not called to confirm my address, and this was cited as a basis for the denial of bail. I submit that in accordance with Section 60, subsection 3, the presiding officer ought to have requested that the landlord be called or that further evidence regarding my address be presented, rather than denying bail solely on this basis. I'm now able to provide further evidence regarding my address, and I have now ensured that other suitable witnesses provide affidavits to the court as stated above. Residential address in bracket, wife, and verification evidence. During the bail proceedings, concerns were raised regarding my residential address. Subsequent to the bail proceedings, my wife, Dorothy Recover, deposed to a confirmatory affidavit clarifying that the correct residential address is 4544 and not 4454, and that the initial discrepancy arose from an error in the lease agreement. The said affidavit confirms that a Wi-Fi service provider invoice reflects and verifies the correct address as 4544 as established during the installation. It is further confirmed that when the investigating officer attended at the premises, the issue of the correct address was addressed and verified using Google Maps in his presence. Neighbor confirmation, in brackets, critical new fact, a neighbor residing at number 4454 confirmed that during a visit by members of the South African Police Services, the investigating officer, he informed them that I do not reside at number 4454. The neighbor further confirmed that I reside approximately 3 houses away, which is 4544, and physically pointed out the correct residence to the police officer during that visit. This information was not placed before the court during the initial bail proceedings. The neighbor only became aware that the matter proceeded in court when he viewed the proceedings on television, and at which point he realized that the information he had provided to the police had not been fully presented to the court. Conclusion, I respectfully submit that the new fact outlined above constitute a material change in the circumstances justifying the consideration of my bail application. I undertake to abide by all bail conditions imposed by this Honourable Court. I therefore pray that this Honourable Court grants me bail on such terms and conditions as it may deem fit. Your Worship, I have the annexures which I would like to read into record, which annexure OBM N1. It's a affidavit of memory Catharina Jacoba Harold. He has indicated his identification number. Her residential address is Dan Pinar 15 Golf View Mahike. The phone number is there. Occupation pensioner. The affidavit reads as follows. I memory Catharina Jacoba Harold, cell phone number. Confirm that Opa Brown Mogotsi resided at number 15 Den Pinar Golf View Mahikeng during his parole period from October 2015 to November 2016. I further confirm that I had to sign documents regularly at the Correctional Services offices to confirm that he was still living at number 15 Den Pinar. I would like to confirm that the day the investigating officer met with my daughter, Memory Harold Jr. at Den Pinar 15, she was not aware that Opa Brown Mogotsi stayed at the said address, as she wasn't living at Den Pinar 15 Golf View Mahikeng during Opa Brown Mogotsi's parole. The affidavit is signed by the deponent being Ms. Memory Catharina Jacoba Harold. It is dated the 8th of June 2026, which is some days after the initial bail application. The annexure OBM N2, it is the affidavit of the neighbor Maxwell Sinukwani. He has stated his ID number. His residence is residing at number 4454, Unit 13, Mabatu. State under oath that on the 20th of May at approximately 12, I saw the police car to the direction of my mother's house, number 4454. When I arrived at my home, my mother told me that there were police officers who asked if Brown Mogotsi's residence is house number 4454, which my mother told them that he does not stay there. He stays 3 houses away from this address, and the police left. Later that same day, they came back and found me and my mother at the house. There were 2 females and 2 male police officers requested my mother's statement to confirm that the property is not Brown Mogotsi's residence. As I was listening, my mother again directed them to Brown Mogotsi's house, and I was showed, and I also showed them the house that is 3 houses away and the wife's car that was present. After my mother provided the police with her statement, the police stated that their records showed that Brown Mogotsi's residence resides at number 4454, and they would remain at that address, despite my mother again insisting and directing them along with me to this actual residence. They also requested a copy of her title deed as proof that 4454 is not Brown Mogotsi's residence. After the police wrote the statement with my mother, Tandiwe Sinukwani, I then left the premises. I'm making this affidavit because I was there when the police officer came to my house, to our house, and they did not mention that Brown Mogotsi resides 3 houses away from my address during the court proceedings as I watched on TV. Brown Mogotsi has 3 years staying there. This is all I wish to state. I confirm that this content is true to the best of my knowledge, and I agree to be bound by this oath. The statement is signed by the deponent. It is also commissioned, dated the 6th of June 2026, which is sometime after the initial bail application. The deponent, which is Mr. Maxwell, also attaches to his affidavit his ID copy. He further attaches to to his affidavit his proof of residence with the address number 4454, Unit 13, Mabatu. And further to this particular bail application, there is an affidavit of the wife, Ms. Dorothy Lukawa, which reads as follows: I'm an adult female person with identity number, customarily married to the applicant. The effects to which I depose here to fall within my personal knowledge unless context indicates otherwise, and are to the best of my knowledge and understanding both true and correct. Ever since there was an issue regarding the address, I investigated and found that the correct address is 4544, and that is also confirmed by the Wi-Fi service provider invoice, which I later found in the house because of this, service providers are able to detect proper addresses during installation. Invoice is attached. When the investigating officer arrived at the house, I informed him that the correct address is 4544 and not 4454. That was confirmed by the Google map in his presence. The reason I initially believed the address to be 4454 is because there was a mistake recorded in the lease agreement when it was entered into with the landlord. I confirmed that the applicant is presently using the address 4544, which has now been rectified and confirmed. I have made the efforts to get hold of the landlord, however he cannot be located and traced. I confirmed that when Mr. Odendal came to the house, he saw the liquor license registered in the applicant's name, in brackets, Brown Mogotsi, clothing, and the Madlanga Commission documents belonging to the applicant. Another important aspect which Mr. Odendal did not mention is that he went to my next door neighbor and 2 additional neighbors for further verification. They all confirmed that the applicant resides in the house where he found me. This is the information I received from my neighbors. I further confirmed that I saw on television that Mr. Odendal did not disclose the information to the court. Even the owner of number 4454, Tandiwe Sinukwani, and his son, Maxwell Sinukwani, also showed him where the applicant resides. The affidavit of Dorothy Lukawa is also signed and dated the 9th of June 2026, which is some days after the initial bail application. She attaches her ID copy. She further attaches the Wi-Fi statement that has been referred to in her affidavit. And in the particular Wi-Fi statement, which invoice begins on the 1st of September 2025, the address which is depicted in that particular statement is 4544, my apologies, 4544, Mohata Close, Mabat, Unit 13, Ngagamudiri, Mulema, District Municipality Northwest. It's a 2-page statement, and there's also OBMN 4, which is also another Google Maps picture, which is the address of 4544 Mohata Close, which is the house belonging to the applicant in this matter. Your Worship, I can confirm that the affidavit of the applicant in this matter has been signed, initialed on each page. There's a manuscript amendment on page number 2 and then initials. Your Worship, with the leave of the court, we beg leave for the Honorable Court to accept this affidavit as an affidavit of the applicant on new facts. Court, please.
Mr. Mogotsi, do you confirm the affidavit, your bail on new facts? And you confirm also the annexures that are attached here? you have signed your affidavit. Thank you. Exhibit A. Is it all, Mr. Sekaja?
Your Worship, that is all we have to submit at this stage on behalf of the applicant, Your Worship.
Thank you. Advocate Beckham?
In responding, the state is in possession of the affidavit of the investigating officer. The statement reads as thus: I, the undersigned Alfred Robert Odendaal, hereby state under oath in English as follows. 1. I am an adult male employed by the South African Police Services, herein after subs as a detective, Lieutenant Colonel with service number, and currently stationed at Provincial Investigation Service, Provincial Head Office, Gauteng of South African Police Services. 2. I have been appointed as a member of the South African Police Services in terms of Section 30 of the South African Police Service Act 68 of 1998, the South African Police Service. 3. I have also been appointed as an investigating officer in the case currently before court, to wit Vosloorus, 413 of 3/2026 and Vosloorus Cas 39 of 11/2025. 4. I am duly authorized to depose to this affidavit and to do so in support of the state opposing the application for bail by the applicant. 5. The facts contained herein are, in my personal knowledge, unless the contrary is stated or the context indicates otherwise. The facts stated herein are, to the best of my knowledge and belief, both true and correct. 6. I was supplied with affidavits of memory, Katharina Jacoba Harold, Maxwell Senokwana, and Dorothy Lekwaba, as well as documentation in relation to bail application on new facts that the applicant wants to bring before this honorable court. 7. My response to the application is, in this regard, is set out as follows. 8. I am not in dispute of the affidavit supplied by a memory, Katrina Jacoba Harold. I followed up with her and want to add that a further statement from memory Katrina Jacoba Harold was obtained and attached as AR 01 to the statement. Her affidavit indicates that this address was not a permanent address to the applicant, as he was only helped to stay at the address whilst on parole. The applicant had no other address. He resided at the address for about 13 months. 9. A Maxwell Senokwana statement supplied. I dispute that he was present when Thandiwe Winnie Senokwana statement was obtained. That we were told or shown at any stage that Opa Brown Mogotsi resides 3 houses from there. Lieutenant Colonel Mzizi, who was present and obtained the statement of Thandiwe Winnie Senokwana at the time attached by my statement as AR 02. 10. I confirm that we did not mention that Opa Brown Mogotsi resides 3 houses from there, as we could not know it. As the address supplied to us by the applicant was house number 4454, and that was the house address that was visited by us to be verified as the address of Opa Mogotsi's residence. 11. I must point out that the statement of Maxwell Senokwana is stamped with the date stamp dated 2026-06-9, but the date by the Commission of Oath is dated 2026 06/2026. This is a concern, as this indicates that the Commissioner of Oath commission the statement in the future. This indicates to me that this could not be this could be a falsified document attached AR 0512. I also believe that Maxwell Sinukwana was possibly intimidated and coerced in making the statement, if the statement was indeed made by him on 2026-06/9. I will elaborate on this belief further down in my statement. 13. Statement by Dorothy Lekwaba. I dispute the fact that I saw any personal documentation of Opa Brown Mogotsi. I indicated in my supplementary statement in the bail application, which is marked as Exhibit D, that no personal documents or other belongings except for few clothing which could be shown as it was requested to verify the address. 14. I want to place on record that at bail application it was placed before the court by the applicant that even at the Madlanga Commission was not at the residence visited by myself, and it can be seen on the photos taken by me attached to my supplementary statement in the bail application, which is marked as Exhibit D, as AR 02. I am disputing it as the applicant wore a bright red jacket at the commission, and that was not found at the address. The photos taken by me also does not depict any red jacket found at the address. 15. Dorothy Lekwaba confirms that according to the lease agreement contract, the landlord Albert Moisa Khosi with ID cannot be traced. However, it is still in my view, looking at the discrepancies of the document as set out in my supplementary statement in the bail application, which is marked as Exhibit D, that this lease document is a false document. 16. It is proven that the person Albert Moisa Khosi is not the registered owner or a person that the property is leased to by the owner in my supplementary statement and supporting documents in the via the statement of Dorothy Lekwaba in the bail application, provided false information to the court and brought the court under false impression on the address 4454 Moshu Street, Mabatu. This now indicates that they deliberately tried to mislead the court, as they must have been in possession of the documents with the right details. 18. In the bail application, which is marked as Exhibit B, I did not have any comment relating to consideration of, in terms of Section 60, subsection 4, paragraph C of the CPA. That would be interfere with state witnesses. However, my view in this regard changed due to the new evidence obtained. 19. On 6 June 2026, I received a call from Lieutenant Colonel Mzizi informing me that she received a strange call from Tandiwe Sinukwane. She informed me that The call did not make sense to her, as she was requested to read the statement back to Thandiwe Winnie-Sinokwane that she supplied, although she was in possession of a photo of the statement. 20. On 8 June 2026, on Monday, I received a call from Thandiwe Sinokwane, and she informed me that she was visited by Dorothy Lekwaba at her house. She was told by Dorothy Lekwaba that she must give another statement stating that house number is the same as Dorothy Lekwaba house number. She informed me that she feels intimidated, and this was now on the third time being visited by Dorothy Lekwaba, and coerced her to give a false statement. 21. I informed her that she must visit or call the police and open a case if that is indeed the case. Paragraph 22. On 12th of June 2026, whilst at court, I was phoned by Thandiwe Sinokwane informing me that again she was visited by Dorothy Lekwaba, and she really feels threatened as she already informed them not to come to her house anymore. She also informed me that on 5 June 2026, while Dorothy Lekwaba was at her house, Dorothy Lekwaba received a call and handed the phone to her, and it was Brown Mogotsi speaking to her. 23. She informed me that she did not open a case and does not know what to do. I informed her that she must supply me with the case number to follow up. She did not supply the case number. She did and supplied the case number. It's Mabatu Cas 81 of 6/2026, a charge of intimidation. 24. I inquired and found out that the case is under investigation. 25. I obtained a copy of the case docket and statements attached as ARO 4. 26. I am now of the view that the applicant can and will interfere with the state witnesses indirectly and directly, even to communicate with state witnesses from prison to threaten and coerce state witnesses to supply false statements. 27. Taking the above into consideration, it is my view that there is a great possibility that the statement supplied by Maxwell Sinokwane, therefore, a reasonable inference should be drawn by the court that the statement was not obtained freely and voluntarily, as mentioned in paragraph 12. The author had been coerced to make such a statement. Your Worship, this was signed by the author of this affidavit. Your Worship, I would want to read the statement of Mzizi into the record, which is marked as AR02. The statement reads as thus. Nontobeko Lorraine Mzizi, state under oath in English that I am a lieutenant colonel in the South African Police Services, attached at Provincial Head Office, Cold Case Investigation Unit, Cleveland Subs, with cell number, paragraph 3, on 20th May 2026, I was requested by Lieutenant Colonel Odendal to escort him to Mabatu to go and verify the address of the suspect Brown Opa Mogotsi on the above case number. At around 12 o'clock, we arrived at 4454 Unit 13 Mabatu. On arrival, we found an African female who introduced herself as Tandiwe Winisunokwan. I then asked the lady if she is residing at that address. She said yes, and she has been staying there for more than 20 years. I then asked her if Brown Opa Mogotsi is residing at the address, and she said no. She said no one by that name resides at that address, and she does not know anyone by that name. 4. I then went to the car that was parked at the gate to inform the other SABC members that was with us about the information that we just received. That is when Lieutenant Colonel Odendal asked me to take the statement of Tandiwe Sinokwane in writing regarding the information that she just told us. I then went back and took a statement from Tandiwe Sinokwane. While I was busy writing a statement, a gentleman entered the house and he introduced himself as Tandiwe Sinokwane's son. I continued to take the statement and left my cell phone number as well as the cell phone number for Lieutenant Colonel Odendal, because the woman was complaining that she does not feel safe, as it was not the first time people coming to look for Brown Mogotsi at her address, at her house. 5. At no stage did anyone showed me or Lieutenant Colonel Odendal a house belonging to Brown Opa Mogotsi, because Mrs. Tandiwe Sinokwane indicated that she does not know Brown Opa Mogotsi. She only saw him the first time in the news on TV. I did not take statement from Mrs. Tandiwe Sinokwane's son, and he never pointed out any house to me or to anyone in my presence. On 6 June 2026, around 18:15, I received a phone call from 069 506 5552, and it was Mrs. Sinokwane on the phone, and she asked me to say what she wrote on the statement on 20th of May 2026 when we came to her house. I became shocked and surprised as to why would she want me to explain what she wrote on her statement. I then said to her, why must I explain? Because she took a photo of her statement before we leave on that day. I could sense that something was not right, and I said if she does not feel safe, she must call the police and report. After the phone call, I immediately phoned Lieutenant Colonel Odendal and informed him about the strange phone call that I just received from Mrs. Sinokwane. I tried to call Mrs. Sinokwane again, but the phone was just ringing. Your Worship, that is the statement, which is AR02. Your Worship, the statement has also referred to a docket that was registered in Mabatu, the docket of intimidation, the docket that was registered by Tandiwe Sinokwane. Your Worship, I would read one of the statements in the docket, which has been compiled by Tandiwe Sinokwani. Your Worship, I will just start off from paragraph number 2. On paragraph number 2, it's on 5 of June 2026 at about 9:30 hours at my residential place, together with my granddaughter Mbali Dlovu. I was asleep when Mbali came in my bedroom and informed me that Dorothy, in bracket, wife of Mr. Mogotsi, wanted to see me. I woke up and I went to the kitchen and I found her. Mrs. Dorothy told me that she came to request me that I should write a statement that my house numbers and hers have common numbers. While still talking to her, a phone call rang, and she answered. She answered it, and I heard Mrs. Dorothy saying she is at her house, Mrs. Winnie Tandiwe house. Dorothy handed a phone to me without informing me who was the caller. I answered the phone, and he said, "Ausi, Tandi sizokuthetha." She told me that a caller is a Brown Mogotsi. I took a phone and handed to Dorothy, and I told her that I don't want to speak to Brown. I further said I don't speak to people who are in prison and that cannot hear me properly because I had a fine. I told her that I am not going to make any statement. I got nothing to do with the house numbers. Mrs. Dorothy Mogotsi then gave me a small paper with her name being Monda, residing at house number 4544. She requested me that I should assist her. I told her that I would rather go to human rights, not at Mabatu police station. She then left the place, and I prepared myself and I went to look for offices of human rights and Mabatu in Mabatu. But unfortunately, I did not find them. I then proceeded to Mabatu police station to report the matter. Upon my arrival at the police station, I met a certain police official, and I related the story to her. She advised me that the issues of house numbers is not my problem. I should go home and rest because I was sick. I confirmed that a person that I spoke with on a phone was Brown Mogotsi, and it was also confirmed by his wife that the caller is her husband, Brown Mogotsi. On 6 June 2026 at about 9:40, I went to the tuck shop, and when I passed Mr. Mogotsi's house, I met his wife Dorothy, and I explained to her that I was not, I'm not going to assist at, in fact, sorry, I met his wife Dorothy and explained to her that I was not assisted at the police station. She then told me that we should go into her house. When we were inside the house, I further told her that I'm not going to assist her. A phone rang, then Mrs. Dorothy picked it up and said, "Ausi, Winnie, is Brown Mogotsi." She tried to give me the phone and I refused to take a phone. Then right there, the place, I then told her that she is making my wife, she's making things difficult for my wife because I didn't want to be a witness. I then said to witness. I then went to my residential place. I know and understand the contents of this statement, and I have no objection in taking the prescribed oath. I consider the prescribed oath to be binding on my conscience. This was signed by the complainant in this Mabatu docket. Your Worship, that will be all. Your Worship, I would then request the statement be accepted as an exhibit. That is all, Your Worship.
Thank you, Your Worship. Your Worship, may I, at this stage, I know that we only commenced around 12:30. Perhaps ask for a short adjournment. We just want to revisit what has been indicated by the state in their opposition to this bail application. I believe 15 minutes will be sufficient. I'm not sure if that will be suitable to the court, Your Worship. I'm not sure, Your Worship, if 15 minutes adjournment will be suitable. Your Worship, I'm reminded that it's also lunch. I'm not sure whether we should rather conform ourselves to a lunch adjournment, which is until 2 o'clock.
We'll be back at 2:45 then.
It's in order, Your Worship. Scott, please.
Kotajan. Thanks. check for me for Bafana outside. We're still waiting for the It's fine, I'll wait. Thank you. We are back on record after we took our short adjournment. Mr. Sekaja, are you now ready?
Thank you, Worship. Your Worship, we confirm, Your Worship, that we have had the opportunity to actually peruse the opposing affidavit together with the annexures of the investigating officer in this matter. Your Worship, we are going to be proceeding to close our case in relation to this particular bail application on new facts and proceed with arguments on behalf of the applicant in this matter, Your Worship. Your Worship, my counsel will be arguing the matter, Your Worship. Scott, please, Your Worship.
Thank you.
Thank-
Advocate Mogomani.
Afternoon, Your Worship, and thank you. Your Worship, Your Worship, this court is seized with a bail on new facts. And what is of common cause is that new facts allow an accused person to renew a bail application after an initial bail application was refused. The guideline is that to succeed, the facts must be genuinely novel, relevant to the application, and have occurred or come to light only after the previous bail denial. What the applicant comes with before this court is solely on the ground of the address which the applicant provided to the court. And this is what forms the basis of this bail application on new facts. The applicant has before this court brought 3 annexures in the form of affidavit. The first one will be that OBNM1, which is that of Memory Yakoba Herald. Now, the submissions that are contained in that affidavit are not disputed. They are further corroborated or agreed upon by the state as an annexure AR01. What the state further goes to say with regards to Mr. Mogotsi residing with Ms. Herald is that he wasn't paying electricity, he was a teenager, he was just released on parole. My submission is that what Mr. Mogotsi has brought before this court, that he was residing at that property, is true and it stands uncontested. Now, we have an affidavit which is OBNM2, which is the neighbor Maxwell Senukwane. This affidavit and the facts contained therein are further confirmed by AR02, which is the affidavit of Colonel Mzizi, where she says in her affidavit that Mr. Maxwell came in and found her taking a statement from Mrs. Senokwane, who is the mother. What is important also to note for the court, Your Worship, is that the deponent of that affidavit is born in 1974. He's a fairly old adult, and he is well within his right to make this affidavit. What the state replies to in that is the discrepancies in the dates. And this the court will find at AR05. That will be the affidavit of Mr. Senokwane. What is of concern to the state is that this affidavit was deposed to by Mr. Senokwane on the 26th of June, 2026, and the date stamp says the 9th of June, 2026. Your Worship, my submission is that the date of the 9th of the 6th, on the face of it, is an administrative issue. The person who puts this stamp is somebody who is employed in the SABC at Mabatu. Whether they update their dates, their date stamp daily, has got absolutely no bearing on this case. And if the state feels so strongly about this and calls it a discrepancy, then Mr. Maxwell Senokwane ought to be charged for perjury. And this has got absolutely no bearing on the applicant before court. Now, Your Worship, according to the investigating officer, he also says that in paragraph 14 of his opposing paper, he makes mention that on the initial bail application, the applicant referred to a red jacket, and that red jacket he did not find at the premises. This is not correct. The applicant referred to a white jacket. The red jacket is the jacket that he wore on his last appearance at Mazanga when he was arrested. Now, sense would prevail that this jacket will not be found at his place of residence. What is also common, Your Worship, is that the address of 4544 is the correct address. The court has been furnished with a letter from the fiber company, and the court has been given a reasonable and a probable explanation as to why this address was given wrong with that previous 4454. And this has been submitted before, and I do not want to repeat it unnecessarily. The defender, the applicant's response has always been that it was the reliance on the lease. And this is further supported by Mrs. Senokwane's statement when she said to Lieutenant Colonel Mzizi that people have been coming to her house asking about Brown Mogotsi previously, and she is scared. Now, that I invite the court to draw an inference that this has been the address that was continuously reiterated to different individuals. Hence, people arrived at the address in the very same way that the investigating officer also arrived at their address. Now, there's also a pin location that proves that the address of 4544 is the real address. Now, what the court is being invited to do is to find adversely on the issue of intimidation. And on submission, that intimidation is not one from the applicant before court. If, according to the statement of Mrs. Senokwane, whatever her concern is meets the requirements legally of what an intimidation is, The state then says that a telephone was handed over to Mrs. Senokwane, and somebody said, Sisi sizokhuluma. Without being an expert on interpretation, it means Sisi will talk. If anything, that does not suffice as intimidation. Now, further thereto, the fact that the applicant before court did make that call and did speak to Mrs. Senokwane, to my instructions, is also denied. Now, Your Worship, there's a statement that was read into the record by the state where Mrs. Senokwane herself says that she went to the spaza shop and she walked into the applicant's house. The same applicant a few pages away, she doesn't know and she hasn't seen, and she's seeing this applicant for the first time on TV. She walks in, she's comfortable, and in the same breath, she's intimidated. I am inviting the court to find that this allegation of intimidation, it's just an exercise by the state to paint the applicant before court with a negative brush, with the hope that the court will find that he continuously remains incarcerated. With the evidence that the applicant has brought before court, there is still no explanation from the investigating officer. Why did the investigating officer say that Mrs. Memory Yakuba Harold does not know the applicant? When the investigating officer himself says that I went there, now that we come with papers to say that Mrs. Harold said that I know this applicant, he resided here. No, he resided, but he was not buying any groceries, he wasn't paying for any electricity. It's an underhanded way to do things, to give court evidence in parts so that the court does not arrive at a fair conclusion. Also, Your Worship, with regards to Mr. Senokwane, the investigating officer says that he was not there, he didn't point out the houses. And the colonel who went and accompanied the investigating officer says that as I was taking the statement, he walked in. Now, still on those aspects, the state still doesn't come and tell the court why this was not said. It was a denial by the state. When these issues are brought to the fore, the state then says, it's intimidation, go and open a case. But if you actually look at the affidavit of Mrs. Senokwane, there is no denial on the part of the applicant that Dorothy, who's the customary wife to the applicant, spoke to Mrs. Senokwane. They are neighbors, they know each other, and she's a concerned wife. And upon realizing that her address was wrong, and the address that was given belonged to Mrs. Senokwane, neighbors in the same community, where is the wrong in asking your neighbor whether or not you can assist? And if the court follows these statements that she wrote, and the court visits the statement that she made when she opened the intimidating case, she says in that statement, she was advised, she was given a piece of paper by Dorothy to go to the Human Rights Commission, and I believe that is important. Now, why would the applicant's wife advise Ms. Dorothy to go to the Human Rights Commission if they're intimidating each other? And what is also of importance, it's the purpose of the visit to the Human Rights Commission. If the applicant's wife was intimidating Mrs. Senokwane, why would they advise each other? And Mrs. Senokwane even goes as further as to visit those offices. My submission is there was no intimidation between the two of them. Now further, Your Worship, she goes and she says in the statement when she opens the docket, and this the court will find at it's AR04. And it's AR04, Your Worship, where she says that when she did not find anybody at the offices of the Human Rights Commission, she then goes to the SAPS because she's not getting help. And when she gets to the SAPS and she relates her story, an officer in that charge office tells her that this is not the place to come and fix issues that have to do with addresses. And she's sick, she must go home. And strangely, after a few days, now she comes back and she's not here to fix the addresses. She is here now to open an intimidation case. It's worrisome that the time that this intimidation case happens is around the same time that the applicant informs the state that we are bringing a bail application on new facts. Now all these other side issues arise. Your Worship, I'm inviting the court to find that the affidavit of Maxwell Senukwane, it's true, it's correct, it's credible, it was made by somebody of sound and sober senses, and there is also no evidence from the state that he is not of sound mind to be making this affidavit. It therefore should be accepted as true. I will further, Your Worship, invite the court to accept that the affidavit of Memory Yakuba Herald in support of the applicant's bail application on new facts is true, it's correct, and there's nothing untoward or questionable with that affidavit. And further, to prove that the applicant knows this deponent, that the deponent gave a letter of the municipal rates belonging to that residence. Now, the same sentiment will follow, Your Worship, with regards to the affidavit of Dorothy Lekhwaba. She has given a fiber statement and she has given a satisfactory explanation, I apologize, as to why this address was wrong. Now, the state says that the submission that the person they entered into the lease agreement with cannot be traced is probably unfounded or untrue. This is a matter, and I believe as we speak, we are on live TV. Now, the owner of that property, if he had no knowledge about the applicant residing at that property, of all these times that this address has been mentioned, he would have done something to remove the applicant there. My submission is that he knows he resides in that property. As things stand, we don't have any eviction application. There has also been no response to the allegation that the investigating officer in these proceedings also went to two other neighbors who confirmed that the address is 4544 where Mr. Mogotsi resides. It is also true that the docket is voluminous and of most it's got complex expert evidence. And the process of understanding same is time consuming, it's expensive because it also needs interpretation from an expert of a similar background. Now, what we then see is that The submission that was made by the investigating officer in the initial bail application that the applicant's address does not exist, it's untrue. And I'm in no position to comment whether that submission was made mala fide or with good intentions from the investigating officer. I'll leave that to the court to make a finding upon. Now, the applicant further states that even a curfew can be imposed. He can also be limited to supervised home confinement when he is released on bail. Now, the issue of interfering with witnesses, as the state has raised in part of their new facts, I invite the court to find that it cannot be reasonably possibly true. It is not the applicant who engaged Mrs. Sinukwani. If there was engagement which is intimidative of any nature, when all these things happened, the applicant was incarcerated. And if anything, the court can order that the applicant not engage with Mrs. Sinukwani, not to go to Mrs. Sinukwani's house. And if they meet each other on the street, the applicant must run away. Now, Your Worship, there's something that I want to draw the court's attention to again. It's the affidavit of Lieutenant Colonel Lorraine Mzizi, who says that when they asked Mrs. Sinukwani that does she know Brown Mogotsi, she said she does not know Brown Mogotsi. But this is the same deponent who went to the spaza and went into Brown Mogotsi's house according to her evidence. Now, I'm also going to invite the court to look into the credibility of this witness or the truthfulness of her statements and whether or not an impression can be formed that there is undue influence of some sort. That deponent also said that she does not know Mr. Brown Mogotsi, and the first time she saw Mr. Brown Mogotsi was on TV. But her son knows Mr. Brown Mogotsi. Now, Your Worship, I also invite the court to look into the fact that we were told boldly on the first bail application that there's video footage, it links the applicant. To date, we don't have it. The matter has been transferred to the relevant court. We are in possession of the discovery, and that footage is not there. There is no footage. Can I take an instruction? Thank you for the indulgence. Your Worship, the entire basis of the case that the applicant is facing hangs on that footage that hasn't been discovered. It's important to reiterate to the court again that the firearm alleged to have been used was not found. Now, whatever other charges that flow from that are charges that can be proven by that footage, which is still not before court. Now, I had informed the court previously that Maxwell Senukwani is a fairly old gentleman. Now, I do not see how, if the applicant's wife was intimidating his mother, he would have kept quiet, and moreover, he would have agreed to depose to that affidavit. Your Worship, I do not have any further submissions. If the court has anything it would like me to address on.
Yes. What is new facts, actually? What is it the court that have to consider as new facts? Because of my understanding is that address number 4544, isn't it the same address which was given previously by pin location?
That is correct, Your Worship. I'll submit that the new fact is the facts surrounding this address and the facts that were given to the court by the investigating officer at that time when he gave evidence to the court are drastically or materially different from what is contained in these affidavits that the applicant has handed up. And Your Worship, I submit that at the time of the initial bail application, this information the applicant did not have.
Which information specifically?
That Dorothy Harold did not know the applicant. That's what the state alleged.
Okay. So with regard to Dorothy, are you saying the court must consider which address between Dorothy and the address that you're now rectifying as 4544?
No, Your Worship, that is not what we are inviting the court to do.
So what is the relevance then to mention this memory?
It borders on the truthfulness of the applicant before court. He responded to say that he knew Dorothy. He resided with Dorothy at the time, and it was a long time ago when he was a teenager.
Fine.
And the state then says to the court, no, he didn't.
Fine, I understand that. But what I'm saying to you is what relevance it is in respect to the new address, the address of Memory Catherine Harold.
It's not, Your Worship, in respect to the new address.
Yeah.
There is no new address here. The address that was there has always been there. And there were submissions that were made to correct the issue of the address. Now, when the only aspect that the court denied to admit the applicant on bail on was the issue of the address, it came to the applicant that the investigating officer had misled the court. It goes to the issue of credibility and truthfulness. If somebody says, I resided here, and somebody comes and says, no, they didn't reside there, they were lying. They are liars. And now you come back and you say that you said I'm a liar. I've got proof that I'm not a liar. I resided there. This is not on the address. It's on the aspect of truthfulness and integrity. Your Worship, may I approach? Thank you for the indulgence, Your Worship.
Proceed.
Now, Your Worship, lastly, on the aspect of memory, the previous evidence was that she has lived at that address for 20 years and she doesn't know the applicant. And it's going to go back again, Your Worship. It hangs on the issue of truthfulness and integrity and whether or not somebody is reliable and honest. Now, Your Worship, on the new facts, I submit that the affidavit of Maxwell Senukwane is also a new fact. The evidence before court was that they got to this house. Mrs. Senukwane, who's Maxwell's mother, says that she doesn't know the applicant. She has never seen the applicant. She only saw the applicant on TV. Now, the son comes and he says, I know the applicant, and I even went as further as to point where the applicant resides, which is 3 houses away. The applicant could not have known that this would have been a fact in dispute when he did his initial bail application. And I submit that this suffices as a new fact. It's material and it's relevant. Is there anything else the court would like me to address it on?
My concern is this, Harold, again. Okay, I understand your argument that the reason why you provide a statement of memory, Harold, is for the issue of credibility and the truthfulness from what the state have said before. But now, for me, it's what your argument is. That address also is correct and it belongs to the applicant. So which one will the court have to consider?
As the court pleases. Your Worship, the affidavit that is deposed to by Dorothy Harold, I just want to...
That is memory.
Memory Katharina Yakuba
Yes.
Harold. I wanted to go to the affidavit quickly.
Yeah.
If one has sight to the affidavit as it stands, there is no mention of the applicant's address.
Okay.
Now, the purpose of this exercise is twofold. One is that even in the initial bail application, the applicant before court was telling the truth. He knows Mrs. Memory Harold. 2, the applicant was painted with a brush that borders on dishonesty. And what the applicant has brought to the court is to say that the investigating officer in the proceedings misled the court, or he lied, if I may so put it bluntly. And that is the sole purpose of this exercise. Now, if the court finds that the affidavit of Mrs. Harold is not a new fact, I'm going to argue and invite the court to accept that the affidavit of Maxwell Sinukwane is a new fact, and it deserves a hearing in this quorum. And if the affidavit of Maxwell Sinukwane is a new fact, then the court needs to look at 3 aspects when you decide whether or not something is a new fact. Firstly, that the applicant is not reshuffling the evidence. Secondly, whether there's been changed circumstances. Thirdly, the totality of the evidence. Now, I'll submit that even if the court finds that Mrs. Harold's affidavit, OBMN1, is not a new fact, but it does tick the box for changed circumstances. It does tick the box for the examination in the totality of the evidence.
Thank you.
Nothing else, Your Worship. As the court pleases, thank you.
Advocate Mekana.
Your Worship, I have gone through the affidavit and I have been listening to the submission of my colleague, and I am struggling to get factors that can be considered as new facts. Your Worship, I would refer the Honourable Court also to the fibre statement that has been referred to. Your Worship, when we look at this statement, the name of the applicant is not there, and also the name of the of Dorothy Lekwabe is not there. So the name that I see is Dorothy Uarabile. That's the name that I'm seeing. So I don't know who is Dorothy Uarabile. Your Worship, it is indeed correct that in terms of the Criminal Procedure Act, new facts are not defined. I would, however, refer the Honourable Court in a case which was decided in this division. I refer the Honourable Court to S versus Farmas. It's a 1996, Volume 1, SACR, 528T, at page 531, from paragraph E to F, Van Diekhorst J. set out applicable approach in the following terms. I quote, "Obviously, an accused cannot be allowed to repeat the same application for bail based on the same facts week after week. It would be an abuse of the proceedings. Should there be nothing new to be said, the application should not be repeated, and the court will not entertain it. But it is an non-sequitur to argue on that basis that where there is some new matter, the whole application is not open for reconsideration, but only the new facts. I frankly cannot see how this can be done. Once the application is entertained, the court should consider all facts before it, new and old, and on the totality come to a conclusion. It follows that it will not myopically concentrate on the new facts alleged." Now, Your Worship, the basis of this Honourable Court to dismiss the application was with regards to the bail, in fact, the address. Your Worship, there's no any other address that has been brought to this court to say that during the duration of the trial, the applicant will now be staying at this address, and this address has been verified by the police. Therefore, this is in fact a new fact. We don't have that before this court. And it was also referred, the applicant referred also to section 60 subsection 3, where the court should play an inquisitorial role. Your Worship, I submit that this court has in fact played that role. This Honourable Court, during the first bail application, the Honourable Court asked that was a house found, and the answer was yes. So if the court was just passive, the court would not have asked such questions. The Honourable Court, just after my colleague has made her submissions, the court engaged her, asked that what are the new facts? That to me, Your Worship, it indicates that the court is also inquisitorial. The court wants to know facts. So it is therefore my submission that the court did not just sit back and did nothing. Your Worship, I will respond to the issue of the video footage. Your Worship, there is no evidence before this Honourable Court during the first and second bail application that the state is relying on the video footage. What the state indicated is that there is video footage and as well as 2 eyewitnesses. The 2 eyewitnesses saw a person alighting from the said vehicle and shooting that vehicle. And with regard to whether they are not being provided with the video footage, Your Worship, still photos were provided, and the state is in fact going to rely on the still photos from the video footage. A video footage will be provided to them, though the state is not going to use the actual video footage, because there is a report that is accompanying the still photos that the state provided the defense with. Your Worship, there's also a mention of a firearm that has not been found. Your Worship, I think that was in fact addressed on the previous bail application. It is not a new fact. It may be so that a statement which has been obtained, only the statement is a new fact, but not the address. The Honorable Court made a finding with regard to the address, and I submit that there's no new facts at all before this court. The only new facts that are before this Honorable Court are that of the state, where the state indicates in its affidavit by the investigating officer, which is AR04, and the fact that there's also a docket that has been registered. I submit that is a new fact, Your Worship, and it is a new fact that does not count in the favor of the applicant. It is a fact that counts against the applicant. Your Worship, that will be all, unless if the Honorable Court would want to hear me on any other aspect.
Status of this case, the alleged intimidation case at Mafike.
Your Worship, the information that is that the state have is that the matter is being investigated. That is all that I can submit.
The prosecution or the DPP haven't taken any decision yet as to whether the
no one has been arrested as yet. So I...
which is open is against the applicant.
It is not against the applicant, Your Worship. It is against the wife of the applicant.
Thank you. Advocate Mahoman, do you have any response?
Just on one aspect, Your Worship, the final statement that the state referred to. Your Worship, in the bundle that was handed up as an application in support of new facts for bail, there is an identity document that belongs to Dorothy. And the first names are Dorothy Uwarabi, which are the same names that appear on that final statement. That is on motion.
If I have to ask, when was this application of a 5 hours made?
Your Worship, I just see an invoice. Can I take an instruction on
Yes.
that? It's got numerous months. Thank you for the indulgence, Your Worship. Your Worship, my instructions are that the applicant is uncertain. However, it should be sometime last year. He thinks November. It's the wife who did, it looks like September. It's the wife who did the application. And the court will note that the amount that is being paid is the same every month. I cannot take the submission any further.
And this is the original document. Approach your client. Approach your client.
Yes, Your Worship. My instructions are that the original fiber statement was handed up with the bundle.
That
the
is
court
which is
has-
handed to the court.
That is the first submission, Your Worship. The second would be that,
You know why I'm asking if it's original, because of it looks like it's a copy for me. So maybe if I have to say, I was expecting original to be in a color form. So is this the original?
yes, Your Worship, the further instruction is that they are normally sent via email.
Okay,
So you then print it out to have it available.
it's fine. The very same statement, can you able to explain the discrepancies of the date? The date that you say the statement and dated the 26th of May 2026, and then on the statement itself relating to, I think is a billing of what they have provided to them. The first date is the 1st of September 2025 with reference number NV 00010703, tax invoice 400 rands. So all the dates are 2025. 1st September 2025, including the second page, which is, or it's more or less the same. But up there on, to my right, your left, 26 May 2026. Is there an explanation regarding that?
Your Worship, can I approach?
Yes.
Thank you for the indulgence, Your Worship. My instructions are that the statement if the court looks at the date that is depicted on the top, it reads page 1 of 1. So it would mean on this particular day, they sent this page 1 of 1. Now, my instructions are that what was printed as the statement, seemingly it wasn't the entire statement that was printed. It started on September 2025 and it continues on a monthly basis. What would then come as another page would be the dates resembling that of this year. But it's a continuous statement and that page was omitted. If the court so requires, the address of the fiber provider can be looked into or a complete statement be obtained. Those are my instructions. Your Worship, we are just trying to see whether this company does exist. Your Worship, may I approach?
Yes.
Thank you for the indulgence, Your Worship. Your Worship, my instructions are that I request that the matter be adjourned for 5-10 minutes so that we can obtain a bank statement to prove that it was paid. But what we had further picked up with my attorney is that the company does exist, and in that place it trades as Extend. It's Next Tech Pty Ltd. So the company does exist. If the court will allow us, we can, in the absence of this page that has been omitted, request a bank statement to prove that for this year these payments were being deducted because it's by way of debit order.
How long do you need?
10 minutes, Your Worship.
10 minutes adjournment. Court adjourned.
The applicant has been having a cell phone and is busy on his cell phone. I'm just placing that on record, Your Worship. As the court uses it.
Your Worship, if I may respond. No. And in any event, when somebody leaves the prison facility because it's unknown whether you are coming back or you are going home, whatever it is that was booked in is given to you. But the cell phone that he's using is the cell phone that we gave him because we are trying to obtain these statements. So we want him to be able to communicate with his wife. I don't see where the error in that is. Yes, Your Worship.
You said you requested a 10 minutes adjournment for you to provide the court with the statement.
We have been in contact with the service provider.
Yeah.
We have also obtained bank statements that belong to the applicant's wife. They've sent them, but we did not want it to be voluminous. I asked my personal assistant to take only the first pages of the 4 bank statements. So I was awaiting for them to be sent back for those 1 dates every month. It's quite voluminous pages for every month. So I was just waiting on that to come back.
Is there a need that you print it out?
Yes, Your Worship.
Because of you can just send it to the court if ever is on software. I can just look at it and it's fine.
We are just waiting for them to be sent back, Your Worship.
I'm saying now, how long are we going to wait? If it's on the software, bring it. We can just look at it on the cell phone, give it to the prosecution, they can check it, and I check it, and that is it. Hand it to the prosecution. What difficulty it is because of is there on a soft copy. You can just show it to the court
Your Worship,
and the prosecution, that's all.
what they were trying to do was to send it from one mobile phone.
There's no need. Whatever mobile is there, hand it to the court. Show it to the prosecution first.
Your Worship,
Unless if ever all of you, the cell phone that you have, you are trying to forward one document from another because of even Mogotsi do having a cell phone now. So
No,
I
Worship,
don't understand as to from where is this document you are waiting from where to from who?
It's
May I approach,
FNB.
Your Worship?
It's FNB
Please.
bank account, Your Worship, and they end on dates which are not the same. The debit,
Ma'am Mahoman, what I'm saying is you do have a cell phone there in your hand. And if you're saying the said copy is in that phone, that's what difficulty for you to just give it to the prosecution. Let them look at it and thereafter hand it to the court.
Your Worship, we've got 4 different statements.
It doesn't matter. Just show which relevant the one that you want to focus on. And mind the time is already 3:20. Show it to the IO. Show it to the IO. Just to clarify, the issue of the statement that is handed through this soft copy on a mobile phone, the data that you are referring to as a payment, is it FNB app prepaid data 27722156
No, Your Worship, there's a payment on the first. It says, I think it says pay snap. It's for 300 rands. We have just taken instruction, Your Worship.
So I'll take it that there is no further statement.
Your Worship, thank you for the indulgence. There's also a proof of payment which I beg leave to hand up, and it corresponds with one of the proof of payments that has been given to the court. It's for that, the 300 rands amount.
There's nothing that was given to the court, ma'am. I've asked you now if it's the same. You said no. So there's nothing.
May I approach you? Worship, my instructions are that there's nothing more. What the cell phone, the fiber company rather, has given is a statement that runs up until the end of December last year.
Yes, there's nothing. That's fine. There's nothing further to provide to
Hence
this
I
court.
say yes, Your Worship, there's nothing further.
Yes. Advocate Pekwan, is there anything further you want to say before I postpone the matter?
Yes, Your Worship, I think it's only about the address. If the court can just take note of the address of the bank statement and the name of the account holder. It's not the the applicant nor the wife.
I've noted that.
As a court
That's why I'm
position.
saying there's nothing, yes, they have said there's nothing further to provide. So I consider that there is nothing further.
Yes, Your Worship, there's nothing further.
The date of the 29th suitable for you for the court ruling? 29 June.
29 June is suitable. Your Worship, we confirm the 29th of June is in order.
Mr. Mogotsi, case postponed to the 29th of June for the purpose of court ruling. You are in custody, Mr. No. Thank you. Kontrajan.
Okay.
Yeah, please.